Memo bi akwaba eba Melodies TV so. Isi yemfa aseda emma Professor Kweku Aza. Denzi ameka se yemfa aseda ma ne se ende ensemo a ekoso ni na no meka se ono no hye ase. Ewo President Akufo Addo aban emu ana amemuo emre no. And Professor Kweku Aza ehun say ye new Chief Justice. Because the current Chief Justice what so time no in the person of Judicial Torkornoo no we di boni wa ye nyama bia entwa ye. Enti ohwa eye Mr. Kweku Aza na Professor Kweku Aza etron krata e de koma President Akufo Addo say yenyi Judicial Torkornoo free. President Akufo Addo twen ya they are all free so on 6th of January, obe hand over the next day. And Ankrate free na so ye abaye say Professor Kweku Aza nsemu a wo kan ni na sebe nyanse bi enim. Nti na nya ade a Judicial Torkornoo ye beyi nende ana ye beyi na ochina. Na Professor Kweku Aza wanka hwe na otina ne baby. Na seni aye kano Professor Kweku Aza ma ye hu say well say President Akufo Addo mre because he could have waited for Mahama to come. But ewo President Akufo Addo mre. And if the President Akufo Addo mre will be to me ayesadia, then it will not be a problem if His Excellency John Dramani Mahama abaye munso obi beye. Because President Akufo Addo time krano. Professor Kweku Aza no pesi yi Judicial Torkornoo e free ho. Na ende His Excellency John Dramani Mahama will nominate a new Chief Justice and our appointee a new Chief Justice and they hear him say committee parliament committee betina say approving no Professor Kweku Aza ababekasa. For me, he is a person of interest me person metin nsemo a woka. Nti ye be ready ni etie nsemo a woka fasa process we ho because he wanted this to happen under President Akufo Addo. Just that President Akufo Addo infi no. Nti ende ni age ana ende den na ekoso ye be kenkan. Na ansa ni ye be kenkan no mesremo. Ma me fa asem wo ntwem. So wotie me na you have a problem with a fat belly, with fuso, and I say you want to lose weight. Why ya emfa? Wa numedra emfa? Mama wati asye efukesiye e dro bi eni obi obeka also we dro ebema wefu akofom bia no boa obe spend usika keke. Now in the comment box no there is a link. A link via ebe direct ede wako book bi. Na book no mia na matro. Nyama miensa mia mitihe me yeye ema me lose 30 kg in the shortest possible time. Ema me fu edru yesi as a balloon a yede pin awom. Inti wu tie me na wonso ope that same experience book ne wa comment box ni muno Toby. Omo ato book no ka atre me say as early as 3 days to 1 week they are seeing improvements. The book currently has a rating of 5-star ewo Amazon. Pe book ni binato. Na wo ye nyama miense wo book ni mu a wo be hu de ebesi we fu betjo weight no esobete. Se wo ni makenkan a ye wo twi video version of the book. No ane se wo bo video ne na wo tie ase de obi kenkan ama no wo beti bibia ase. So wo he na se why ya book no wo nya na untumi click link na comment box ni mu number na that screen ni so no 055-807-4986. Fresa number no. And now WhatsApp yen. Ubenya book no. Very simple. Young consem mo. Professor Kweku Aza or say the president has nominated Justice Baffoe as Ghana's next Chief Justice. Justice Baffoe's story begins in Goso, where he attended the local authority primary and middle schools, a background that connects him deeply to the rural experience. He later moved on to Konongo Odumase Secondary School, earning both his O-level and A-level certificates before studying law at the University of Ghana. And for those who followed me yesterday, and I was reporting on this story, me born a background in the same way Professor Aza Ekani na munim. As he once put it, he, the late Sir John, his roommate at Saba, and former Chief Justice Enin Yeboah Evandao were the trial of village law students at Legon. Prove that Ghana's highest courts are not reserved for the privileged alone. From those humble beginnings, he steadily climbed through every level of judiciary. He began as a circuit court judge in Duayao Nkwanta, served as a high court judge in Kumasi, and was later elevated to the Court of Appeal and the Supreme Court by President Akufo in 2006 and 2008, respectively. He assumes office at a moment of crisis. Public trust in the judiciary is at an all-time low. Citizens see a system plagued by backlogs, arbitrary transfers, opaque empanelment practices, and troubling entanglements with the executive. At 68 years old, Justice Baffoe has only 2 years before mandatory retirement. He faces a clear choice: create a legacy or coast to retirement. And indeed, it's true. Because Papa no ha, wabon the brave ye, wa ye ne jume ye, I can't 2 years. So 2 years ya okay. I think say the was a war enim any legacy a will be created. Na broni kase legacy and ye kase legacy a will be created. Ade a wo be ye edieja edimpa. Or say if he chooses the path of legacy, here are Gogo's top 10 reform ideas that can define his tenure and restore public trust in the judiciary. It is a legacy no ochuswa. Ono Professor Kwaku Aza Womano enyama 10 eye Justice Baffoe ediswa ebema ne legacy no 18 1. Abolish long legal vacations. Replace lengthy court vacations with staggered leave, ensuring courts remain open and functional year-round. Also, one of the things Pape Wanyane say, Sa Ghana legal vacations be breyomoko. A lot of people don't even know this, but Embrebi etumisi wa Ghana ha, right? Court in Yejuma. Cases nina yede too hot. They intia say legal vacation. Into say one, sa long legal vacation ya court ne kono. On abolish it. Because if you understand, court no ewo ho for krono ana ewo ho se be di asem. Dey bi anso asemba. Na so mo am court mo se mo ko vacation. Asem nso nko vacation. Inti no on replace sa legal vacations no ati ase on ensure say the court remain open and functional year round every day bia, just like it happens in America or other developed countries. Every day bia court ebie. Every day bia court ebie. 2. Timelines for case progression. Work with the rules of court committee to set clear timelines for different categories of cases. Justice should no longer be denied by delays. And I agree with this. You see, one of the problems you have in Ghana delayers in courts. And then, me to me obi wo case bia for 10 years it is still pending in court. In mama, especially assassin ho manson. People can litigate in court over assassin for over 10 years. Ebeduna ni pakono na just ni sunsum crefia de nim. Inti o se papa person create legacy on set clear timelines. Inti say ye assassin ho manso a judge wudi asem no ma asem no empa 3 months. Within 3 months, I was so dear assembly. And I think say ebeboa. Say a election because it happened in this country. Samuni Amobekaya, the first election petition in 2012. It took a long time. It took over a year, right? But from that time, 2020, MPP time, and Omoka said that be election petition, yeah, set clear timelines for it. Yempese beche sabium. Until latest by a month or say 2 or say dieno na case ni ye or 2 or 3 na election 2020 election petition. It was fast, it was clear, so there were clear timelines. So if we can do for election petition, we can do for other cases as well. A criminal trials yen look at omo ebo Maxwell Mahama ekunu no. Look at how long the case took. Over 5 years. Into no yan set a clear timelines. Aya chrono dia acha 2 months yendi we. And I think say I agree it will be a good legacy if he's able to do that. The third point, I say randomized case assignments and transparent transfers. Adopt a secure digital system that assigns cases to judges randomly, reducing perceptions of bias and enhancing fairness. And indeed, I agree. Transfers and reassignments must follow transparent criteria like workload, expertise or promotion, and be handled by court administrators with the CJ playing only a supervisory role. One of the sins of Judicial Torkornoo ayede pame no the assignment of cases. Say allegedly who say nkrofo bi case bi corner case no ye diama nkrofo bi na wa sheda asesa judge na wo case ni so. One of the sins. It was say papa yi wa ba no o make sure so benya system bi a system no randomly ebe assign judges to a case. And I don't understand why we don't really have that system. Because we also in this country, especially during the era of Judicial Torkornoo, there were certain people be and a very controversial cases. So now you who says Anglophone in a case super yen say unanimous ABC, and indeed unanimous isida. There were senior Supreme Court judges now were mounting sensitive cases so even though they had the experience. It is to me yen say near yen random and found say we senior we junior e Supreme Court we experience and now we are enya yen ye selecting the pako betina case ni so a random system. It is a case bi ato and one say system no wa pa wa peke asumesi obentin una kotina case ni so a ebeboa. And then the assignments what you say and the transfer of judges in so. And I think say I mean for legacy sake Baffoe born in Ankasa because on Ankasa who say one of the sins I ye get to talk on no dia any kwanso will be catching no on Ankasa also who say any kwan say or yes I mistake so. So I think say it is a good one. That's the third point. The fourth point, I say full bench for constitutional cases mandate that all constitutional matters be decided by a 9-justice panel. The Redo Directive, empaneled automatically by software to protect legitimacy and consistency. In the case be a constitutional case be no, you making sure say 9 judges na better na so. Na sa judges na so no, you can automatically no software be na select chief justice. Software be na select sa 9 judges no. It's any matter involving constitution ni bia no you make sure say 9 judges in it na so. An example mo amohwe afenyu marking send your dimirika eko Supreme Court kokoye gidi ya edi enimguase bre Judicial Torkornoo no saa de no it's case bi sa ko Supreme Court enye Judicial Torkornoo na enye chief justice no enam ke wo say select judges no software be randomly be selecting 9 judges a bet in that case no so no more be case no. Fifth point, reform interlocutory appeals, adopt a final judgment rule to curb abuse of piecemeal appeals, balancing efficiency with protection of substantive rights. Enti lawyers omuni madie bi efe no interlocutory appeal ati asiye di case na yakose o ade we send ye koy yemfa appeal me appeal say we ni on say there are certain things bi a cases no drag che obi wo nim say na asem nye de. And I think say one of the things in here na also one of the sins ye di Judicial Torkornoo because I will share interview na Tadosori who is the lawyer for Daniel Ofori no petition and nam so ne Judicial Torkornoo o share Tadosori in interview na asem o kan say they had won the case against EcoBank. Now so because Judicial Torkornoo allegedly had problem with Daniel Ofori a non person Daniel Ofori be winning case ninti. Now Ecobank for to me file some, I mean, delayance be, appeals be, we say get to talk on so allegedly, right? And as someone what can say? Yen set a final judgment rule to abuse or to keep the abuse of sa appeals here. Obi we need judgment there. Now so because obi wo ha or no our time our resources no. But pastor obema wo judgment we win no nim say we need judgment ne there. Now so be share down man the lawyers need delays and to say obi give you up. Tini kwansi is also ansem so. And I think say it is right because a lot of people use systems to abuse the court or to abuse the court process. The third point was say open access to legal materials. Create a free, searchable, continuously updated database of case law, statutes, and regulations. Now, point where the main melodies are material ekran nebe boame. Inti yembie yen access a legal material. And I think say, I've forgotten the name, but some Ghanaian developers have started doing that. They've created an AI. For the legal system in Ghana. Oh, mi refio mudin. Oh, let me search. AI for legal system in Ghana. Maybe. Last time I saw it and I was happy about it. Some Ekobi Nkrofobi ne creative our system no. I've forgotten the name. Oh, I'm not seeing it here. Any. Esquire. Yes, I've seen it. Esquire. I've seen it. So there is an AI for the legal system in Ghana, and they are yet to launch, right? And so you can start a trial and all that. But if you want to view the demo, you can also view the demo. So this is it. Your friend AI, or say meet Esquire, your trustworthy AI legal assistant. Okay, but imagine if the judiciary itself had such a system, an AI application. Send your melodies me ha. Ebia, sometimes the person me research, me tremo send me use to charge GPT the research no. Se Ghana mbredi ba na Ghana BBC. Ana yavanza odi oye Ghana ni police ni chill. Say why ye BB. You can just go and ask the AI say ni, are you right? Law no and him fana etia the end was say the AI will show you whatever you have to do, and you can even show to the police say the way you Ghana mretia say, and the AI might even go further to give maybe a police toll-free number, and you can even call the police head or BB and report the police right there and then or something. What you say? So I think say it is good. Into that part no me he can never boame. So you see it is a good thing. Into the judiciary, if he wants to leave a legacy, for me, I'll say Nkrofui ISR AI, you know, he should sort of liaise with them. Nkrofui only a private firm, and I'm sure said they will be, letting people pay if Ghanaians want to use the system. But the judiciary can liaise with them and probably even sponsor them so that it will be free to Ghanaians. What you say? I think say it's a good thing. Now, the 7 points, or say, plain language justice, and I agree with this. Plain language justice requires Supreme Court decisions to include concise, public-friendly summaries, no more than 2 pages. And one thing about Ghana, your judges, I mean, for people who have followed me for a while, you know, say, I have read judgments from Supreme Court over here. Sometimes judgments, maybe to me read 1 hour near gusu read it was say judges no omo ruling ewo cases so no more ruling na enye plain language obi abeti ase me nkonko yes we your lawyer ansa obeti ase because omo bro for name nsem omo keka na sometimes challenge easy inti 2-page judgments ade no say there we ye nti enam we sunti you do why you bone why is what ase ebeboa. I think it's also a good one. Also mandate modern simple English in pleadings and rulings. Replace archaic formulations with clear statements. Example, replace save as herein before expressly admitted the defendant denies each and every allegation of fact contained in the statement of claim as if same were herein before set out and traversed seriatim with, except where specifically admitted, the defendant denies all other allegations. Indeed. Okay, and someone welcome, bro. No, I like this. Professor Azar, God bless you. The 8 points will say performance audits of judges and courts. Introduce periodic performance reviews of judges and court registries focused on case management, timeliness, and integrity. Publish results annually. Any regulations or practice directives issued by the Chief Justice must strictly comply with Article 159. Do not issue directives by fiat. Yenya auditing of judges and courts, and I agree. So judges ni huni se dibia ye audit you omo nsem omo rulings ni omo nyama ye check you omo a, they will be forced to follow the guidelines. The 9 point, technology-driven court administration. Accelerate the modernization of court infrastructure with e-filing, electronic service of process, and virtual hearings. Use technology to reduce backlogs and cut costs for litigants. And I agree. And also, me peneso technology aba. Yen use technology ni enfanya online virtual hearings and the likes. In fact, for me, a suggestion I'll give, say we should have a dedicated, probably maybe a digital TV station for our courts. Or if not TV station, every court case should have at least Zoom hearings, online hearings, virtual hearings, so that say me melodies meti abontin meti ha na be a case be because of court. I don't need to be in court. And then me wadam phobia or court. Right? Me wadam phobia and de or court. Maybe see, I can't say yeah, know all the cases. What you say, me sometimes we can start with the serious cases, okay? But even in America, it happens. You can just join in a court session and listen to what is going on. So we can start with maybe a dedicated digital channel. Inti melodies me to hona me pese me and the court case being courts being a yedi asem any random case biana. It can even help us. We will get close to judges and lawyers. We will see send your moody and some. It will help in a long way. And that's my suggestion. Let's create a dedicated TV station or a dedicated YouTube channel krana for serious court cases for now. It's a court case be a cause to serious court case be and saying okay the murder of the immigration officer na. Omoko court judge AD asem no the cause wo court ni na no. Ni nso yete online yehwe ana yete ye TV so and you say be a election petition nko and ye deco. And I think say it will help. Once we are able to do it for election petitions, we can do it for all other cases as well. It will involve resources there, but let's try to do that. Technology aba. 10th point, ethics and accountability framework. Strengthen the judicial council and disciplinary mechanisms to swiftly address misconduct while safeguarding judicial independence. Institutionalize ongoing training on ethics, case management, human rights, technology, and complex financial crimes like looting. Judges must stay ahead of the curve. And I think say it is good. It is good. To address misconduct. What you say? More addressing misconduct in Yama while safeguarding the judicial independence. Or say, if confirmed by Parliament, you have a historic opportunity to reverse, decline, and restore credibility. These reforms are not exhaustive, but they set out an urgent action plan to rebuild public trust, judicial efficiency, and independence. Above all, remember that you are the Chief Justice of the people, not the President's judge. P.S. Ye depose no beto ho. Ye nye comprehension consultants. Daye. I like this. I like this. Montreal mwadwen e comment box ni mo. Medase.